Well, good afternoon. My name is Alain. I'm a senior policy officer in the international team at the Information Commissioner's Office. I've been invited today to speak about the twin challenge of data protection and right to information. And I will develop that in a few slides in a couple of minutes. This presentation will focus on a specific section of the UK Freedom of Information Act, Section 40, which in a sense deals with the reconciling the irreconcilable. The Freedom of Information Act contains a list of 23 exemptions. Section 40 is one of these exemptions under the Act. It exempts public authorities from disclosing personal information. This is a copy of the specific section which we will be looking in more detail over the next few minutes. The Act is available online at www.legislation.gov.uk. I said that Section 40 was about reconciling the irreconcilable. There is a tension between openness and privacy, and the ICO, as regulator for both, certainly receives its fair share of complaints or requests for advice. However, we should argue that, contrary to popular belief, the Data Protection Act, or the UK Data Protection Act, is not about keeping information secret, nor does it give specific rights, as is in the Freedom of Information Act. It sets down principles to strike a balance between protecting individual privacy and organizations' obligation to be transparent and cater for the needs of the business and public sector. Section 40 of the Freedom of Information Act aims to resolve the overlap between FOIs, or Freedom of Information or Access to Information, and subject access, and protect the privacy of individuals who work for or have dealings with public authorities. Section 40 is one of the most commonly used exemptions since Freedom of Information Act came into force. It's also one of the most complicated due to the crossover with the Data Protection Act. We acknowledge that public authorities can understandably be nervous about releasing personal data, because if they release when they shouldn't, they do risk breaching the Data Protection Act and potentially incurring a civil monetary penalty or other form of regulatory action. However, if they get it wrong and don't release information, they risk breaching the Freedom of Information Act. There's no avoiding the issue. An authority has to be aware of both responsibilities. In a nutshell, an authority which is considering disclosure of information, which includes some personal data, should always consider the data protection implication. In the next slides, I will discuss how the ICO views this key issue in light of its casework and tribunal decision. As previously mentioned, Section 40 is the most commonly used exemption that the ICO sees in complaints raised with us. 1,293 decision notices were issued in 2015, and Section 40 was cited as in around 20% of these. But decision notices do not provide a full picture. Approximately 25% of all complaints received are resolved informally. Out of these 25%, half of these informal resolution related to cases involved Section 40. And the public authority managed to avoid formal resolution by resolving the issue with the complainant. What we read from this situation as they present to us is that the public authority could have generally engaged more with the requester at the outset, perhaps by reaching an agreement with the requester to narrow the scope of his request, or reduce the amount of personnel that had to consider, and thereby identify what information the requester was primarily interested in. The public authority could also have given a more detailed explanation to support its application of Section 40, or simply even by being more willing to thoroughly revise its decision when it refused to disclose information. Through our handling of casework, we have identified our top 3 issues which we believe public authorities sometimes struggle with. I will discuss each of these issues at length in the next part of my presentation. So what are personal data? It's important to note that 2 conditions need to be met before Section 40 of the Freedom of Information Act can be engaged. Does it relate to a living individual, and is that living individual identifiable? It seems obvious, but complaints we receive show it's not always the case for public authorities. And we have a hard time to tell them that the fact that information is personal data does not mean that it is automatically exempt from disclosure. For instance, is the data being processed to learn, record, or decide something about a living identifiable individual, or as incidental consequences of processing, could you learn or record something about them? Fairness. An authority needs to consider the consequences of disclosure, reasonable expectation from the individual, a balance between rights of data subject and legitimate public interests. For instance, those in senior position can expect to be more accountable for the decision, and therefore it might be considered more fair to release personal data about, say, a head of a public sector department with responsibility for decisions that impact the general public than about a junior clerk. Also, if information is already in the public domain and widely accessible, why would it be unfair to disclose? What are the circumstances? We appreciate that it's not always easy where to draw the line. Disclosure. It's often a difficult area as it involves making decisions about how or who can be identified once information is redacted or anonymized. There might be a need to consider whether a motivated intruder might be able to deduce the identity or particulars of an individual, a household, or a business from other information in the public domain, as well as the mosaic effect, or I would say the ability to establish linking case between output from different data sets. This often involves statistical information and complaints files, but public authorities should carefully consider if some information should be anonymized or redacted before reaching the decision. We sometimes find that there is a lack of proper consideration as to the ability to identify individuals from statistical information disclosed by public authorities, and they should be mindful of that fact. So let's go back to the basics and explore what data and personal data are. Data and personal data are defined in the UK Data Protection Act 1998. Those are commonly accepted definition, and I don't think these need to be widely expanded on further than what the Act already provides. So data is being processed automatically or is recorded with the intention of being processed automatically, is held as part of a relevant filing system, forms part of an accessible record, or is recorded information held by a public authority. So let's go back, take a look back at Section 40 of the Freedom of Information Act. And particularly at Section 41. So the personal data means data which relates to a living individual who can be identified from those data, or from those data and any other information which is already in the possession or is likely to come into possession of the data controller. It also includes any expression of opinion about the data subject or the intention of the data controller or another person towards the data subject. It's also important to note what the Act says about sensitive personal data. So sensitive personal data is defined separately from personal data because of the nature of those data. So it either can consist in data relating to the racial or ethnic origin of the individual, its political opinion, religious belief, trade union membership, physical or mental health condition, its sexual life, or any commission or alleged commission of an offense, as well as proceeding for an offense committed or alleged to have been committed, and the proceeding of such. So what does Section 40 of the Freedom of Information Act says exactly? Well, it says that information is exempt, information if it constitutes the personal data of the applicant. This is an absolute exemption. Section 42 provides that information exempt information if this is the personal data of someone other than the applicant, and either the disclosure of the information to a member of the public other than under the FOI will breach a data protection principle, which is become an absolute exemption. If the disclosure of that information to a member of the public otherwise done under the Freedom of Information Act would breach Section 10 of the Data Protection Act, which is a qualified exemption. And lately, whether the personal data is exempt from disclosure in response to a subject access request by any exemption of Part 4 of the Data Protection Act. This is a qualified exemption. I will explore in further details what are the Data Protection Act principles, which constitute an absolute exemption. But it might be worth exploring what a qualified exemption is. So it requires the public authorities to complete a public interest test as they apply exemption to the information that has been requested. And the public interest test for a qualified exemption should take into account whether, in all circumstances, the need to withhold the information outweigh the public interest in it being disclosed. This balancing act is in favor of the requester, as the balancing of the public interest test can be challenged through the compliance system. Under an absolute exemption, the public authority doesn't have to disclose the information within scope. There is no public interest test applied to absolute exemption. So, for instance, they could be exempted because of national security reasons, court records, permanent privilege, or because the information was provided in confidence. I mentioned Section 10 of the Data Protection Act. Section 10 of the Act provides that an individual is entitled to require a data controller to cease or not to begin processing for specific purposes or in a specified manner any personal data in respect of which is a data subject, on the ground that, for specified reason, the processing of that data or the processing for that purpose or in that manner is causing or is likely to cause substantial damage or substantial distress to him or to another person, and that damage or distress is or would be unwarranted. Information that is the personal data of the applicant is exempt under Section 40.1 and should be dealt with as a subject access request under Section 7 of the Data Protection Act. Why? Well, someone making a subject access request has to prove their identity and is generally afforded greater rights to their information than they would have under the Freedom of Information Act. The main purpose for the exemption is to make sure the request is dealt with under the right access regime, the Data Protection Act in this case, rather than a request from any other member of the public. And again, this constitutes an absolute exemption, so there's no requirement to consider a public interest argument. But consider this. Is everything requested the applicant's own personal data? What happens if it's about mixed personal data? It's not always clear if information contains personal data of someone else other than the applicant, for example, in complaint case files. It can often be difficult to separate the applicant and third-party personal data. In this case, we would anticipate that the public authority treats the request as a subject access request and exempt it under the Freedom of Information Act, and also consider whether the third-party personal data is exempt from disclosure to the public under the Section 40.2 of the Freedom of Information Act. In second, there should be a question as to whether it would be a breach to the Data Protection Act if it were to give the information to anyone who asked for it. And here, they need to consider whether they need to apply the subject access provision under Section 7 of the Data Protection Act to the third-party personal data. Section 7 of the point 4 of the Data Protection Act states that where a data controller cannot comply with a request without disclosing information relating to another individual who can be identified from that information, he is not obliged to comply with that request unless either that individual has consented to that disclosure or it is reasonable in all circumstances to comply with the request without the consent of the other individual. So we need to note that under Section 40.2, it says that disclosure of the information to a member of the public otherwise done under this Act would contravene any of the data protection principles. So the duty to provide information under the Freedom of Information Act does not in itself provide an exemption from the data protection principles. So what are those principles? Generally speaking, if information requested under Freedom of Information can identify a living individual or and if disclosing that information would be unfair to that individual, then it's likely to be exempt from disclosure under FOI. However, the concept of fairness is not straightforward. It will depend upon the context, the individual, what personal data is, and whether it's sensitive personal data, which is afforded greater protection under the Data Protection Act. Sensitive data. Given its nature, it will most likely be that it would not be within the reasonable expectation of the individual that their data would be disclosed. There may be exceptions to this, where the information is already publicly known and remains so. For instance, a local MP's political affiliations are likely to be well known. Even though it is sensitive personal data, it cannot be reasonably said that they wouldn't expect that information not to be released. Consequences on the individual, where broadly, fairness requires not processing personal data in a way that would have an unjustified impact on the individual. A public authority should consider the nature and level of damage and distress that is likely to be caused by the disclosure. The higher it is, the more likely it's going to be unfair. But the damage or distress must be likely to be caused by the disclosure. In some cases, this will be very clear. For instance, disclosure of bank details exposing individuals to risk of fraud. In others, it will be less clear. For instance, disclosure of medical records, which may lead to distress to the emotional well-being of the individual. There might be other factors, such as where the information is in the public domain or not. Reasonable expectation of the individual. The actual expectation of the individual in any case are not relevant. The public authority must decide objectively whether it will be a reasonable expectation of the individual. The public authority may seek the views of the individuals, but it's not obliged to do so. When assessing the context, it should also consider the expectation of the individual both at the time of the information was collected and at the time of the request. Should it include any assurance given to the individual and whether more recent development may have altered what those reasonable expectations would be. There are also expectations of privacy. Individuals' rights to privacy is protected. However, there is also the distinction between public and private life for those working in public roles. Factors in this will include the seniority of the role, whether the work in a public-facing role, and whether their position involves making decisions on how public money is spent. They also need the nature and the content of that information. For instance, information about disciplinary hearings would attract a greater expectation of privacy. And finally, the legitimate interest. Even where it may not be within the reasonable expectation that the information will go out, and where disclosure may result in some damage and distress to the individual, if a sufficiently strong public interest in disclosure exists, it may outweigh those factors. For instance, in the recent case in UK of the NP's expenses. There are a number of scheduled conditions, but in reality only two would apply. So consent is necessary for legitimate interest under Schedule 2, and explicit consent and information made public as a result of steps deliberately taken by the data subject. That's Schedule 3. Are likely to be relevant to disclosure under FOI. In order to satisfy Schedule 3 Condition 1, a public authority would also need to have a record of the individual having specifically consented to the disclosure of their sensitive personal data to the world in response to a freedom of information request. And consent is often difficult to obtain and rely on. This condition says that processing will be justified where the processing is necessary for the purpose of legitimate interest pursued by the data controller or by a third party or parties to whom the data are disclosed, except where the processing is unwarranted in any particular case by reason of prejudice to the rights and freedom of the data subject. Satisfying this condition is in a three-part test. There must be a legitimate interest in disclosure to the public. The disclosure must be necessary in order to satisfy the legitimate interest, and the disclosure must not cause an unwarranted harm to the interests of the individual. Most of the work in relation to the first and third points have already been covered off by fairness consideration. The only remaining test to satisfy is whether the disclosure will be necessary in order to meet the legitimate public interest identified. In practice, this required a public authority to examine the public interest identified, and then consider whether those interests could be met in a manner which interfere less with the privacy of the individual. If there's no less privacy intrusive means, then the public authority must consider whether the disclosure would have a disproportionate or excessive impact on the legitimate interest of the individual. Much of this would have been done under fairness or similar arguments around the nature of the information, the role and seniority of the individual in question, which will be relevant. So going back to disclosing the information of a third party, I said that you need to comply with Principle 1 of the Data Protection Act, so that personal data need to be processed fairly. It also needs to be processed lawfully. What we mean by lawfully is that we refer to common and statute law, but it's rarely an issue. It's also very industry-specific legislation and regulation. In a nutshell, there might be it might be unlawful to disclose information if there's another exemption that may apply, for instance, like Section 44 or Section 41, like a breach of confidence. And then for a disclosure which is unlawful could also be considered to be intrinsically unfair in a case. Finally, as I said, the ICO has been dealing with a lot of complaints and has received a lot of requests for advice. And it's often the case that we deal with cases that have been refused or access have been refused by the public authority. So what's important is that when we refuse a request under Section 40.1, the authority means that the authority has identified a request as a subject access request. So we recommend that the public authority deal with the request diligently. If they're refusing a request under Section 40.1, then they don't need to ask the requester to submit a separate subject access request, but at the same time they need to be satisfied that all requirements under the Data Protection Act are met. If the authority relies on Section 40.2, it's about disclosing information or personal data from a third person, then the authority needs to explain how the exemption applies, clarify whose personal data is involved, why it can be disclosed in any way. For instance, it would be a breach of the first principle of the Data Protection Act, and it need to explain how that principle applies. The authority must also have considered whether the information contained in the public document could be redacted, for instance, or could be disclosed in parts only. It's also important that the public authority explains its decision-making process. The requester will be less likely to complain if they understand how exemption has been applied. The ICO has released or published a lot of guidance and information online. Those are all the guidelines that exist, and we'll be happy to provide more links to that if necessary. Hopefully those few minutes presentation will have given you a flavor of how we see the interplay between data protection and freedom of information in the UK. If you have any further questions, feel free to contact me directly. So my name is Alain Capper, and my email appears online at the moment, so alain.capper@ico.org.uk, and I'll be very happy to provide more details about how we enforce the legislation in the UK. Thank you for your time.